Right out of the gate, the judge is moving fast. No dramatic opening statements, just straight to business. First-degree murder in Texas isn't just serious. It's among the most severe charges in the state. We're talking 5 years to life behind bars. Notice how calmly the defendant responds. That's either nerves of steel or someone who knows a deal is already in place.
22-39802 is now called the State of Texas versus Derante Kelvin Everfield. That is you, sir?
Yes, sir.
Present with Mr. Kelly, your attorney, and the state's attorney.
Yes, sir.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
We waive full reading, Judge Simpson.
In summary, this indictment alleges that on or about April 14th, 2022, in Jefferson County, Texas, you committed the first-degree felony
This is yours. It's
of murder by shooting the complainant, the victim, with a deadly weapon, namely a firearm. Do you understand what you were charged with?
Sir.
If convicted of a first-degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable?
Yes, sir.
An agreement has been.
Did you catch that? A murder charge, punishable by life, reduced to 10 years through a plea deal. That's a massive drop. Why would prosecutors agree to that? Lack of evidence? A witness issue? Or maybe they wanted to avoid a risky jury trial? What do you think? Smart move by the state or a potential miscarriage of justice?
Reached in your case, if you would be pleading guilty, sentenced to 10 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
mine.
Yes, sir.
How do you plead to the allegation of murder in this indictment, sir? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, Mr. Kelly. Is everything true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No
and
objection.
it's without objection, it's admitted. Among other things, sir, the states you are mentally competent to enter your guilty plea. This is being made freely and voluntarily. You know what you've been charged with. The indictment's read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1, it's made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, please, sir.
I will follow this agreement. Anything else to add on that? If
Not on that case, Judge.
Just, Your Honor, we're just requesting the allocution be allowed for tomorrow morning.
Yeah.
Bam.
But anything else to add on this?
No, Your Honor. not.
Okay, if nothing further, I will make the findings that Mr. Everfield, you are indeed mentally competent to enter your guilty plea. It's being made freely and voluntarily. You know what you've been charged with here. It went black. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser inclusion of this. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer, all who so help you God. State's Exhibit 1 is made a part of the record for all purposes. Anything else to add?
Not on that case, Judge.
All right, I'm going.
The judge just added a deadly weapon finding. In Texas, that's more than a scary phrase. It means the defendant will serve at least half of his sentence before even being eligible for parole. No early release loopholes here. That 10 years, he's doing a minimum of 5, period.
Do you understand what has happened today, sir? Okay. The only other additional finding the court is going to make is that the judgment shall reflect affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense, and that will be reflected in the judgment. Do you understand? Anything else? Now we have another case.
Yes, sir.
Call the second case, Mr. Everfield, and this is cause number 23CR1270. Does the defendant waive a formal reading of the indictment and the arraignment in this case?
Yes,
Can
we
we
do.
proceed in summary?
Thank you.
In this particular case, sir, the indictment alleges that on or about April 14th, 2022 in Jefferson County, Texas, you committed a third-degree felony of tampering or fabricating with physical evidence with intent to impair it in a murder investigation. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in this case. You would be pleading guilty, sentenced to 10 years in prison. This one's concurrently.
Yes, Judge.
Will run concurrently with the murder case that you were just sentenced to in cause number 22-39802. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes,
So you're pleading guilty voluntarily, and because you are guilty,
yes, sir.
I show you what's marked as State's Exhibit 1 as well in this case. Did you sign that? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, again, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation of your attorney on this case. All true it states, so help you God. State's Exhibit 1 was made a part of the record for all purpose. Pre-sentence report waived.
Yes, Judge.
If nothing further, I'm going to follow this agreement and find Mr. Everfield in this third-degree felony of tampering or fabricating with physical evidence. I am going to find you are mentally competent to do this. You will have an understanding of what you're charged with. You understand fully the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I so find you guilty of this third-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years, and this sentence shall run concurrently with the sentence in the murder case previously assessed today in cause number 22-39802. Do you understand what has happened, sir?
Yes, sir.
Anything else?
Nothing more.
That is all. Thank you.
Thank you.
We now call cause number 25 CR 642, the state of Texas versus Andrew Diaz. That's you.
Yes, sir.
Present with Mr. Adams, your attorney and the state's attorney. And does the defendant waive a formal reading of the indictment and arraignment? In this case, can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about April 19th of this year, 2025, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon. You understand what you are charged with here?
Yes, sir.
This is a second-degree felony, which means
Listen carefully. Diaz is pleading guilty, but the court isn't entering a conviction. This is called deferred adjudication, a kind of legal limbo. If he follows every probation rule, he avoids a felony record. But one slip, one violation, and the judge can slam him with a full 20-year max sentence. Talk about a ticking time bomb.
convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached where you will be pleading guilty and placed on deferred or unadjudicated probation for up to 10 years. And is there any restitution here? No. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan in this case?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty?
Guilty.
So you're pleading guilty voluntarily, and because you are guilty.
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand
Yes,
what you're charged with? The indictment's been read to you. Are you ready? You understand it fully? You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer here. All true.
Yes, sir.
State's Exhibit 1. is made a part of the record for all purposes in this case. Pre-sentence report is waived.
Yes, sir.
I will follow this agreement and find, Mr. Diaz, you are pleading guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, Your Honor.
There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt in this case. However, the court is going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You do well, it can be shortened to 1/3 of it. There will be terms and conditions of probation, including anger management, which helps you make decisions under crucial decision-making situations. And that will help you. Also, the court, even though you have not been found guilty, so long as you follow these terms and conditions of probation, court finds there is sufficient evidence to support an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. It will not have any practical application unless you fail. Then your probation can be revoked. You can be then found guilty, sentenced up to 20 years in prison, and that prison sentence would have to be served at least 50% because of the affirmative finding of a deadly weapon. So a lot riding on you doing well.
Sir.
Are you going to do well?
Yes, sir.
Okay, it's up to you. Anything else? That is all. Two cases are now called 22-40954 is a motion to revoke probation. That's the older case. And then there are two new cases that have newer cases, 25 CR 858 and 859. Does the defendant waive formal readings of the indictments and the arraignments in these cases? Can we proceed in summary?
Yes, sir.
Everything's going to run concurrently, correct?
Yes, sir. Yes, sir.
This is all running
It's all
together.
different. Yes, sir.
All right, I'm going to take up the two new cases first in order, 25 CR 858 and 859. In 858, and in these cases, the defendant waives formal readings of the charging instruments. We can proceed in
Yes.
summary. In 25 CR 858, sir, this indictment alleges that on or about March 5th, 2025 in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here, Fred, in this case?
Yes, sir.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed that cannot exceed $10,000. Do you understand the punishment range in this case?
Yes.
An agreement has been reached where you would be pleading guilty, sentenced to 20 years in prison to run concurrently with other cases. Is that your understanding of the agreement?
Yes.
What is he going to do on the MTR plea?
5 years.
Okay, so it will run concurrently with that case as well.
Yes, sir.
It's not written here.
Yes, sir. All there. Okay.
So this would run concurrently with the next case we're going to go into, 859, and the probation case that we're going to be handling in 22-40954. Is all of that true and correct?
Yes, sir. Yes.
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir, of this first-degree felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily because you are guilty?
Here's where the courtroom energy shifts. We've gone from murder and assault to aggravated sexual assault of a child, one of the most serious crimes in the Texas Penal Code. The mandatory sex offender registration for life? That's not just paperwork. It's a permanent label that follows a person everywhere, every day.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. I'm going to hold this in abeyance for just a minute. I'm going to go into the next case pending, 25 CR 859. And again, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that also on or about March 5th, 2025 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child by sexual contact Do you understand what you are charged with in this case?
Yes, Your Honor.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in this case where you would be pleading guilty, also sentenced to 20 years in prison to run concurrently with 25-0858. And let me add this other motion to revoke probation case 22-40954. Is that all true?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this case as the previous case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
On each of these cases, I'm showing you what's marked. These 2 cases you have pleaded guilty to, I'm showing you what's marked as State's Exhibit 1. Did you sign those documents voluntarily?
Yes.
In each case, understand them, discuss them with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, these states you were mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer in each case. All true, so help you God.
Yes.
States Exhibit 1 in each case made a part of the record. Pre-sentence reports are waived here.
Yes.
On these 2 cases, I'm going to follow these agreements and find in each of these cases you have pleaded in 25 CR 858, the first-degree felony of aggravated sexual assault of a child, and in 25 CR 859, the second-degree felony of indecency with a child. You have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes.
There is sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in these hearings to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of these 2 felony offenses. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years confinement. In each of these cases, these sentences shall run concurrently. What this means also is that you have additional obligations of filing documentation, and you are going to have to register as a sex offender. And because this aggravated sexual assault involves a child younger than 14 years of age, this is going to be for life.
Yes, sir.
You're going to have to register. And failing to register properly can result in the filing of a felony charge and additional prosecution. So you have an affirmative obligation. The probation officer, when they go over this judgment with you, you're going to be able to do that to explain to him
What do you need to explain, Judge?
the obligations of
Registration.
under the sex offender laws. And do we do that immediately through y'all, or is that done through the jail? Because he's got to do that immediately. And I don't have paperwork here. How do we get that accomplished?
What documents specifically is it that we reviewed?
Sir?
What
I
documents?
don't, well, he's got to register under the sex offender program.
I think
And
based being sensitive.
Well, I'm not telling him how to do that. He just has the obligation. It has to get done. Somebody's got to help him with that. He's not on probation.
I think when he
he's
is released parole, I think they.
I think he's got to do it before he's released on parole. Right?
While he's in custody, I don't think he has a duty.
They'll handle it.
Until he's released.
Correct. I agree with that.
So they'll take care of that once he's paroled.
Okay. Well, the prison authorities will know that he has that obligation, and they know what his convictions are.
And his parole.
They can take care of the necessary within the institution for security based upon those matters.
We do have the notice that's normally signed by defense counsel and the defendant today, Judge. That's on the tablet. That should be done. While you're looking at that, Judge, I've made contact with the family about the plea, but they weren't able to be here before the entry of the plea today. I will confirm if they still want to do an allocution, and we may schedule it later this week, Your Honor.
Did you do that, Mr. Deuce? We may need to bring the defendants back because they have a right under the law
They do.
to
Mr. Hampton, let me know if this-
Yes, sir.
confront the defendant and allocute on what harm has occurred here. But I don't see anything in the tablet that.
I don't think it's been done by the defendant, Judge. I think it needs to be done.
In 22-40954, does the defendant waive a formal reading of this motion to revoke probation here? Can we proceed in summary?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand. In summary, this motion to revoke probation filed on May 28th of this year, it states that on April 10th, 2023, in this court, you were sentenced to 10 years in prison, and that was probated or suspended for 10 years for the third-degree felony of theft of property. Is all of that true and correct, sir?
Yes.
So you were convicted, sentenced to 10 years in prison, placed on probation for 10 years, and this motion alleges that you have violated that order of probation. I don't see anything. There are no allegations about the two substantive crimes he has pleaded guilty to. All right. Number one violation states that you committed the offense of illegal possession of a controlled substance on or about March 10th, 2025 in Hardin County, which was in violation of condition 1 of your probation order, which states don't commit a crime. Is that true?
Sir.
Are you pleading true to that voluntarily? And because it is true as it is alleged.
Yes, sir.
Do you understand that a knowing and voluntary plea of true, one or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or data? Your probation can be revoked and you can be sentenced to no less than 2, no more than 10 years confinement in prison. So for this third-degree felony of theft. Understanding that, do you insist on pleading true today?
Yes.
I find.
And now we see the domino effect. A single probation violation, just one, can bring back old sentences and stack them on top of new ones. It's a harsh reminder that in Texas, freedom often hangs by a thread. What would you do if every small mistake carried this kind of weight?
When you're pleading true voluntarily, you understand and appreciate the consequences of pleading true. And then finally is allegation 6. This states that you violated your probation by failing to remain in Jefferson County, Texas, and that you were in Hardin County, Texas on or about March 10th, 2025 without permission from the Jefferson County Adult Probation Officer Department or this court in violation of your probation order. Is that true?
Yes, sir.
And are you pleading true to that voluntarily because it is true as it is alleged?
Yes, sir.
And again, the same warning, do you understand that a voluntary and knowingly made plea of truth to one or more violations of probation, that is a grant, a motion to revoke probation. The probation can now be revoked and you can be sentenced no less than 2, no more than 10 years confinement in prison. Do you understand?
Yes.
Knowing that, you insist on pleading true today.
Yes, sir.
I find you are pleading true voluntarily to this allegation as well in this motion to revoke probation, and you understand and appreciate the consequences of pleading guilty. An agreement's been reached where your probation would be revoked and you would be sentenced to 5 years in prison to run concurrently with these other cases. Is that true?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
This states the case will run concurrently. This probation revocation will run concurrently with 22-41105. I don't know what that is.
that was a prior motion to revoke state jail felony. He was previously sentenced to 2 years state jail.
You're asking it also run concurrently with these other two
Yes,
cases, correct?
Yes, sir.
All right.
But that's not in here. We're gonna add them. Is that right? That's okay with everybody?
Yes, Your Honor. That is a partisan intention.
Okay. I find there is sufficient evidence, again, supporting this motion to grant it by a preponderance of the evidence or greater as allegation 1 and 2 of the motion to revoke probation dated 5/28/25 in this cause number 22-40954. Those allegations are found true. Your probation is hereby revoked. You are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years in prison. And this sentence, in this case, shall also run concurrently with the sentences in cause numbers 25 CR 858 and 859 of 20 years confinement in prison that have been set earlier through the sentencing of this court in accordance with the plea agreements in those other two cases. Anything else to add?
No,
No,
sir.
Your Honor.
That is all.
Here's the.
Thanks, Judge.